how does probate work in Florida? Here are the basic steps and basic understanding of how probate works in Florida. So one of the first things that happens is somebody owned either real estate or they had a bank account or some kind of IRA or Roth or asset, and it's in their name. And there's no payable on death beneficiary, there's no ladybird deed or magic language on title, and they own the property in their name. And they die, and whether there's a will, no will, in those situations, to transfer the asset of that person to the rightful heirs, there would need to be a process called probate. And probate is the filing of paperwork in the courthouse to transfer that asset from that person to the heirs. And what many people do is they go to an attorney, they fill out the paperwork, the attorney files the paperwork in the courthouse that formalizes the whole process to bring the right orders before the judge to then eventually distribute the assets of what that person had out to the beneficiaries. So if it's real estate, it's maybe transferring that title through petitions and documents that transfer that interest. Maybe it's homestead property, or maybe it's just secondary homes or other property, land, anything out there that was in that person's name, and eventually transferring that title through the probate court, through petitions, and moves it to those people. Or maybe it's a bank account or an IRA or 401k, and those documents that are filed in court are now used to establish who the heirs are and the assets that are in play. And if the creditor period is still in play, meaning in Florida, if it's been less than 2 years and creditors are around for that person that owned the property, or maybe they had Visa, MasterCard, other kinds of bills, medical bills, those are things that have to be addressed in the probate as well. Now you know a little bit more about how probate works in Florida.